Welcome to our first part of the EU AI Act course, Risk-Based Regulation, Obligations and Governance, Mastering Europe's Digital Decades, Platforms, AI and Regulation. In this first part, we're answering a simple question. Why is the EU regulating AI now, and why with harmonized rules across member states?
The EU's core is to treat AI regulation as a single market governance and as trustworthy AI project. Harmonization matters because AI products and services cross borders instantly. So fragmented national rules create legal uncertainty and uneven protection.
And the trustworthy AI framing is the EU trying to set conditions for innovation without normalizing harms, especially where AI touches health, safety, and fundamental rights, the holy trinity of the AI Act. A short overview. First, regulatory necessity, why AI becomes a regulatory and constitutional concern. Second, the regulatory concept of the AI Act. Third, key criticisms, what the AI Act gets right and where it remains contested. Let's start with necessity. The AI Act is not just tech regulation. It frames AI as a constitutional and public interest issue, because AI systems increasingly structure how power is exercised in society. That's why you see these concepts on the slide. Persuasive power structures, structural dependencies, and socio-technical interactions. The point is, AI doesn't land in a vacuum. It sits inside institutions, markets, infrastructures, and organizational incentives. And also the epistemological dimension. AI systems don't just make decisions, they shape what is notable, what counts as evidence and knowledge, and how people are categorized. Power dimensions in AI applications are manifold. The centralization of infrastructure, AI models, and data appropriation in the hands of a few big tech global players. The black boxing of AI systems where people cannot understand, explain, or comprehend the path to a system's output, which decides upon them. Or the individual and highly systemic dangers that AI systems can cause without providers taking accountability.
Historically, a lot of EU work started with ethics guidelines. The shift you see in the AI Act is that ethics becomes less of a soft aspiration and more of a normative pillar, which is often the case for creating law. But importantly, the AI Act establishes that pillar mainly through health, safety, and fundamental rights.
And one detail to flag, the protection of ethical principles is not uniformly operationalized in binding provisions. See, for example, Recital 8. It's doing a lot of that ethical signaling work, and it reads as follows. This regulation supports the objective of promoting the European human-centric approach to AI and being a global leader in the development of secure, trustworthy, and ethical AI, as stated by the European Council. And it ensures the protection of ethical principles as specifically requested by the European Parliament.
So, what does regulating societal power mean concretely? It means that AI as a driver of systemic effects, not only isolated failures.
The same building blocks apply here. Power structures, dependencies, socio-technical interactions, but now we name the stakes. The erosion of fundamental rights especially. The risk of AI systems in various scenarios are well documented. Nevertheless, it is difficult to successfully counter the narrative of innovation that surrounds AI in the current discussions.
Think of rights impacts that are not always dramatic single events, but cumulative. Lots of autonomy through behavior, influence, exclusion through automated scoring, discrimination through proxies, or chilling effects through surveillance, like deployments. Something that the concept of systemic risks is picking up for general purpose AI systems, a topic we will talk about in another video.
The regulatory necessity argument is when these effects scale like they do in AI systems, individual consent and individual remedies are not enough. This is a structural governance problem. A major mechanism behind the societal power we talked about is data power. Data power is a special form of informational power asymmetry. It's not only about who has more data, it's about who controls infrastructures, who has market dominance, and who gets to produce knowledge, including categories, benchmarks, and what counts as performance.
So when we say AI regulation, we are often also regulating data extraction models, platform ecosystems, and the downstream dependencies of public and private actors on a few technical providers. Finally, a short preview on fundamental rights, because this is the normative anchor the AI Act keeps coming back to.
For example, in Article 27 of the AI Act under Fundamental Rights Impact Assessment, or short FRIA, in practice, fundamental rights here is shorthand for a bundle of protections. Think of privacy and data protection, non-discrimination and equality, freedom of expression, due process, and effective remedy, to name only a few that are also anchored in the Charter of Fundamental Rights.
And the key regulatory move is these rights aren't treated as an interaction between the state and the rights of a subject, but rather as a new concept, relationship, and structure the AI Act creates for testing AI systems.
They are treated as compliance objects and a hard piece of the regulation, things that should shape design, deployment, documentation, oversight, and accountability. But the AI Act does not always live up to this fundamental right promises. In the next segment, we'll start turning that into the AI Act logic, definition, scope, and the risk-based structure that determines which obligations apply, when, to whom, and how.
Thank you for watching our first session on the AI Act.
We are looking forward to welcoming you back in our next video.